Hello, everybody. We'll get started in about 1 minute. Everyone, welcome to the Environmental Law Institute's event analyzing EPA's new Soot exposure standard. My name is Madison Callahan, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We're so excited to have you joining us this afternoon. We have a great program planned for you all today. I want to take a moment to thank our wonderful speakers for taking the time to join us as well. Today's event will be recorded and will be posted to the ELI website for members to view later. So if you're an ELI member, check back to the event webpage in a few business days to find the recording. You can also find our panelists' slides on the event webpage. So you're welcome to go there now and check them out if you would like. We'll put the link in the chat. We'll be taking audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program. While the chat will also be open for you to post your observations throughout the webinar, please post any questions that you wish for our speakers to address in the Q&A box rather than the chat. I'll now go ahead and hand things over to today's moderator, David Woolley. David is a lecturer at the UC Berkeley Goldman School of Public Policy and the executive director of the Center for Environmental Public Policy. He has over 30 years' experience with electric power regulation, climate policy, and Clean Air Act implementation. David is also a counsel at the Oakland firm of Keyes and Fox, a law practice focused on distributed energy resources, and is a consultant to the Energy Foundation. You can find links to all of our speakers' full biographies online on the event webpage. David is also the co-author of West Group's Clean Air Act handbook as well. David, I'll hand things over to you to get us started. Thank you all so much for being here.
Thank you, Madison, and welcome to everyone to this webinar on EPA's new PM 2.5 National Ambient Air Quality Standard, or NAAQS for short. Thanks for that introduction, Madison. The only thing I'd add is that I was an Assistant Attorney General at the New York State Law Department for many years, working on Clean Air Act issues leading up to the 1990 Clean Air Act amendments. Our panel today includes three people with deep experience with this rule. Amanda Leiter works at EPA and was involved in the PM 2.5 fine particle rulemaking, formerly an environmental law professor at American University. Manuel Salgado from WEACT. WEACT is an environmental justice organization. Manuel has experience with EJ advocacy and training in atmospheric chemistry. Peter Zeisel from Environmental Defense Fund is an attorney with experience in regulation of major industrial sources, including oil and gas and petrochemical industries. More detailed information on the speakers is available on the ELI website. So I'm going to just do a short context setting here. On February 7th, EPA strengthened the National Ambient Air Quality Standard for particulate matter, specifically the primary or health-based standard. It strengthened a 1997 rule, which was the first national fine particle standard in the United States. The new rule lowered the allowed annual average limit on fine particles by 25%, from 12 micrograms per cubic meter down to 9. As this audience knows, the NAAQS is one of the central pillars of the Federal Clean Air Act, which creates the attainment objectives for state implementation plans. The NAAQS are part of a complementary set of measures to reduce air pollution, including a wide range of technology standards for large sources of stationary and mobile sources, and as well as a range of state and local emission regulations. On stationary sources, state and local governments can be more stringent than the federal. And on mobile sources, California can have more stringent mobile source standards, with other states copying those. There's quite a complex web here addressing air pollution in the U.S. Well, this rule comes out at a time when EPA has been very busy. EPA recently or is currently working on regulations for methane emissions from oil and gas operations, finalized in December 23, I think. There's a power plant rule in the works. There are new vehicle emission standards recently adopted or in preparation. Just yesterday, EPA issued an ethylene oxide limit on sterilization plants. EPA's interstate air pollution standard or rule was recently argued in the U.S. Supreme Court. This involves Section 126 of the Act. EPA issued a national climate assessment in November. What we're going to do here today, each of our panelists will speak for about 5 to 10 minutes, to be followed by a lot of time for questions and discussion. Please put your questions in the Q&A box. What we'll do is we'll go through each of the panelists' presentation and then go to questions. So at this point, I think I'll turn it over to Amanda. Amanda, are you ready to start? We could go.
I am. Sorry about that. The mute button moved from where I am used to it being.
Okay. Welcome, Amanda.
Thank you very much. As David explained, I am a lawyer in the General Counsel's office at EPA. I've been there since July, so I'm still fairly new. And one of the things that I have worked on since I've been there is just the finalization of these new PM 2.5 NAAQS standards. So let me start by sort of running you through the basics of the rule. Particle or soot pollution, and specifically small particle pollution, which we refer to as PM 2.5, is one of the most dangerous forms of air pollution. We have extensive science that links exposure to PM 2.5, which is also called soot, to harmful cardiovascular effects, including heart attacks and strokes, as well as harmful respiratory effects, including asthma attacks and asthma-related deaths. The current standards were set in 2012, the current standards for PM 2.5. The Clean Air Act requires that the Environmental Protection Agency, or EPA, review each of the national ambient air quality standards at 5-year intervals and revise them as necessary based on a health-based evaluation. The prior administration reviewed the 2012 standards and made a determination in 2020 to retain the standards at their 2012 levels. However, EPA had a variety of recent studies suggesting that the health effects of PM 2.5 exposure occur at concentrations that were allowed under the previous standards. In other words, concentrations that met the previous standards, nevertheless, were associated with significant health effects, with additional studies that demonstrated that public health improvements resulted in areas that met the previous standards. We could see improvements in health as PM levels were lowered still farther below the current standards. The quantitative risk assessment that we conducted, on which the final rule is based, also estimated that the previous standard could allow thousands of PM 2.5 associated deaths per year. The Clean Air Science Advisory Council, which advises EPA on its decision-making in this regard, advised that we lower the standard. And so based on our evaluation of all of the available scientific and technical information, EPA decided to revise the level of the primary, as you heard, primary health-based annual PM 2.5 standard down to 9 micrograms per meter cubed to protect public health with an adequate margin of safety as the Clean Air Act requires. So this is just a summary of that same information in chart form. So as you can see, the 2012 standards are summarized in the central 3 columns. And the standard that we're talking about is the annual standard for PM 2.5, the annual primary standard, which had been set at a level of 12 micrograms per meter cubed. The form, or the sort of way that the average is measured, is the annual arithmetic mean averaged over 3 years. The prior administration, as I said, reevaluated that in 2020 and chose to retain it. We just reevaluated it and chose to lower it to 9.0 micrograms per meter cubed. I think that somehow these slides are advancing faster than I intended them to. So let me just summarize what we did with the other standards. With the other standards, we chose to retain them at the levels that were set in 2012. And I wanted to run through the reasons for those decisions as well. So first, with respect to the 24-hour standard for PM 2.5. So if you just imagine a timeline of particulate matter levels, you could imagine sort of daily peaks in particulate matter levels as factories cycle on and offline, traffic goes up and down at rush hour, et cetera. The annual average, of course, controls the overall levels of particulate matter. The 24-hour standard is intended to ensure that there aren't individual days with dangerously high spikes of particulate matter levels. We evaluated the 24-hour standards that were set in 2012, but the Clean Air Science Advisory Council did not reach a consensus on whether we should revise those levels, or that level, sorry. The majority recommended revising the level down from its current level of 35 to a range between 25 and 30. The minority recommended retaining the standard, and we chose to retain the standard. And the reason for that is that we didn't have good data teasing apart the effect of the annual standard from the effect of the daily standard. So air quality analyses suggest that the annual standard controls across most of the country, and that an annual standard will actually continue to limit peak daily concentrations as well. And we couldn't conclude that the current 24-hour standard is inadequate in areas that meet the new 9 microgram per meter cubed annual standard. In other words, once areas come down to that 9.0 microgram per meter cubed annual standard, our data suggests that that will also be sufficient to control against the dangerous daily spikes that we're concerned about. So apologies for the slide glitch. I'm going to pass over this one, which I've already shown. And tell you about a couple of other aspects of the rule. So first, the rule newly factors environmental justice considerations into the siting of particulate matter monitors nationwide. The idea here is to ensure that we're accurately measuring particulate matter levels near communities that are at risk or overburdened communities. The 2019 Integrated Science Assessment and Integrated Science Assessment Supplement, on which the rule is partly based, identified children, older adults, people with pre-existing diseases, including cardiovascular and respiratory disease, minority populations, and low socioeconomic status populations as at-risk populations. And the new siting criteria basically requires states or localities, as they're adding new air pollution monitors or moving existing monitors, to consider at-risk communities and their proximity to air pollution sources of concern, such as major ports, as listed there, rail yards, airports, large industrial areas, et cetera. So it doesn't require installation of new monitors, but it does say when you are installing new monitors, or if you're moving existing monitors, the proximity of these at-risk communities to air pollution sources of concern is one of the factors that should be taken into account. This is just to give you a sense of the breadth of EPA's existing air monitor network. There are about 4,000 of these monitors nationwide. They're operated mainly by states and tribal environmental agencies. The agencies then send their hourly or daily measurements of pollutant concentrations to EPA's database, which is called the Air Quality System, or AQS. Some of the monitors are read manually, but many of them are automated. And I apologize for not including non-mainland US. This is my own technical insufficiencies. I couldn't figure out how to pull those pieces of the map onto my slide. So apologies for that. A second change that the rule makes is to adjust the air quality index to reflect the new scientific data we have showing greater health effects at lower levels of PM 2.5. So the air quality index is the tool that states, tribes, and local governments use to inform the public about air quality. You hear it if you listen, as I do, to NPR every morning. They'll tell you today is a red air quality day. Sensitive populations should limit their time outdoors, et cetera. The modifications in this rule include, as you see in the yellow highlight, an update to the lower breakpoint between yellow and orange based on the revised level of the annual standard, and an update to the upper breakpoints to reflect the latest scientific evidence we have about the dangerous effects of high levels of PM 2.5. So just to summarize in one slide, the benefits that we expect from this rule include up to 4,500 avoided premature deaths, up to 800,000 avoided asthma cases, up to 290,000 avoided lost work days. That's a projection in a single year, 2032. And our estimate of the net benefits of the change is could be as high as $46 billion. In addition, the stronger PM 2.5 NAAQS advance environmental justice by reducing particulate pollution that disproportionately burdens at-risk communities. And also, as I mentioned earlier, the change to the siting factor will ensure that at-risk communities are better accounted for in siting air pollution monitoring stations. And finally, the rule complements continued deployment of funding from the Bipartisan Infrastructure Law and Inflation Reduction Act, both of which aim to encourage the adoption of clean technology nationwide and bring down both particulate matter and other sources of pollution. And last but not least, this would not be a complete EPA presentation without one of the agency's favorite slides, which is to document for you that these advances can be achieved consistent with economic progress. So in particular, since 2000, particulate matter concentrations have gone down by about 42% in outdoor air nationwide. And during that same time period, the US GDP has increased by 52%. I will stop there, but I do have some slides to talk about implementation of the new NAAQS during the question and answer period.
All right, thank you very much, Amanda. So turn it over to Manuel.
Thanks, Dan. So my name is Manny Salgado. I'm Federal Research Manager for We Act for Environmental Justice. We Act is an EJ organization that was started in Harlem back in the late 80s. Since then, we have grown a great deal. We have about 50 employees now, and about 12 of us reside here in Washington, D.C., where we have a federal policy office. We Act is one of the few, if not the only, EJ organization with a presence, a full-time presence in DC. So we're very proud of that. Our mission is essentially to build healthy communities by ensuring that people of color and or of low income are able to participate meaningfully in the creation of sound and fair environmental health and protection policies and practices. So to put that a little bit more succinctly, what that means is that we feel that the people who have been harmed the most by systemic environmental racism and carry a large amount of the burden of environmental pollution in this country should have a seat at the table in deciding, how we remediate that and how we move forward with those concerns in mind. Next slide. So I started at We Act a little bit under 2 years ago, and so I've been here for the entire process of the PM NAAQS. I was, part of the initial comments that we submitted. We've done a lot of advocacy on this subject, and now I'm also part of the response to the finalized rule. I think from an EJ perspective, it's safe to say that the Biden administration has been the best administration that we've ever had in recognizing EJ concerns and uplifting them and trying to address them. And Amanda just showed you a lot of the ways in which this rule will benefit EJ communities. We're going to see improved health across the board. We're going to see, as she pointed out, lower numbers of premature deaths, lower hospital visits, lower amounts of hospital visits due to asthma and other respiratory diseases. We're going to see fewer deaths. So there are going to be a substantial number of lives that will be saved due to the implementation of these rules. What's unfortunate is that we could have saved more. I think that, what I'm going to try to show in these next slides is that while we're very happy to see progress on this issue and other issues, the burden that communities of color carry is so substantial that we really need to be taking action that addresses that fully. And unfortunately for us, when we review the final rule that the EPA came out with, it just leaves us wanting a little bit more. So we did recommend updating the rule to the 8 micrograms per cubic meter standard. I'll show here a little bit how EPA modeling shows that would have saved substantially more lives. And more importantly, it would have saved Black lives. Black Americans carry a substantially larger burden of air pollution than any other demographic. That's reflected in mortality rates within the Black population. And I think that that's something that we really need to strive to address in every way possible. Next slide. So there's an idea and a concept that comes to mind a lot when talking about environmental justice principles, and that's the idea of equality versus equity. And so equality brings to mind, an equal effect across the board, right? And so this is really pertinent to air pollution. While equity means that we have an end result where everyone benefits equally or has the same end result. And so it's a little bit nuanced, but I think in the next slides, you'll be able to see exactly what I mean by that. Next slide. So these are a couple of figures from a study that was published in 2022 that show concentrations of PM over the last, since the turn of the century. And so on the figure on the left, on the y-axis, we have PM concentration, and on the x-axis, we have a time series, so a moment in time. We can see clearly that since the year 2000, average particulate matter concentrations have dropped across the board, right? The EPA has been doing a great job, the NAAQS are working, and we've seen that everyone across the board is exposed to less particulate matter than they were in the year 2000. This is fantastic. This is what we want to see. But we can also see in the second part of that figure that although we have all seen these decreases across the board, certain ethnicities and demographics still face a higher burden of that pollution. And so the racial disparity in the amount of particulate matter that a white person in the United States is exposed to and a Black person is exposed to is still different. And we still see that Black residents, Latinos, Asians all carry a significantly higher burden than white Americans when it comes to particulate matter pollution. Next slide. This is a little bit more of a complicated scientific figure, and I wasn't sure if I'd be able to explain it adequately enough to include, but I threw it in here because for me, it's almost like a Rorschach test where you look at it and, you know, some people will see different things. And when I look at this figure, what I see is redlining. I see a history of discriminatory practices in the United States that have led to people of color being in closer proximity to point sources of pollution. And so the way you want to look at this figure is that the colors here represent different sections of the figure here represent different industries, and it's color coded to where if that industry is in red, that demographic receives a higher than average amount of pollution from that industry. The size of the bar then corresponds to how much that disparity is. And if you look at the bar for white people on the left, you'll see that it is inversely, it's the inverse of every other bar up there. They are the only demographic where the majority of industries give them a lower amount of pollution, whereas people of color in general, Black people, Latinos, and Asians all see a higher load of pollution from almost every industry listed on there. The big one of note to me that pops out is industrial sources. All people of color have an above average exposure to industrial sources, while white people on average in the United States see a much decreased amount that is below average. This is because people of color are living in communities that are sited near these facilities due to historic practices like redlining that have made sure that those polluting facilities are located in communities of color. Next slide. So these next figures that I'm going to show all come from the regulatory impact analysis that was released last year when the EPA first proposed this rule. And they come from Section 6, which is the chapter on environmental justice. These are very dense, and so I was very hesitant to include them, but I think that they do provide a really good set of data that the EPA was using to guide the decisions. And what you have on this chart here is you have different demographic groups that are split up. So you have it done by race, you have it done by ethnicity, which essentially breaks down to Hispanic and non-Hispanic. And then you have other demographic statuses such as poverty, educational attainment, age, etc. And then you have different columns which dictate the current standard, which is the 1235, and then the 4 proposed standards on the right. And so the darker blue denotes a place where that demographic has a higher exposure to PM, and then the concentration is listed there. And so what we see is that the 1235 standard, which was before this rule was finalized, that white persons in the United States had a lower exposure than every other demographic group on here. That's not a surprise. I just showed you a bunch of other information that showed that. But then we also see that at the end result, white Americans still have a lower exposure at the 9 micrograms or at the 8 micrograms level. And so that disparity persists regardless of the level that we set it at. Next slide, please. And so this is the inverse of what I just showed you, and this is actually the amount of reductions depending on the level that would have been chosen. And so, as I stated before, the disparity persists, but what we do note is that the disparity is smaller at the 8 micrograms level as opposed to the 9 micrograms. And so what we see here is that we could have made a bigger dent in these racial disparities had we gone with the stronger standard. Next slide. This is perhaps the most stark of these slides, and this is mortality per 100,000 persons for each of these demographic groups directly from particulate matter. And what we see here is that it's really clear that Black persons living in the United States carry a much higher burden of air pollution exposure, and that's reflected in their mortality levels. Now, this is not all due to exposure. This is due to the cumulative burdens that they carry in other aspects of, our socioeconomic system that inevitably impact the health of Black persons. But it shows that they are far more at danger to succumbing from poor health due to particulate matter than any other demographic in this, living within the U.S. The chart below shows the effects on that mortality, so reductions in mortality at each one of these levels. And we do see an 11.5 reduction at the selected 9 micrograms level. And so, as you know, I try to make clear what we're seeing is a reduction based on the level that the EPA decided to choose. But if you look at the 8, it's more than doubled. We go from 11.5 to 25.6 as a reduction. That is substantial. And so those are lost lives that the EPA has decided to leave on the table by selecting the less strict standard here. In addition to that, we do see additional lives saved in each one of the other demographic categories. So while Black persons would benefit the most at the level of 8, they also suffer the most, and there are benefits across the board. Next slide. So I think it's really clear here that people of color face higher levels of pollution across the board. Air pollution mitigation strategies since the Clean Air Act have had substantial effects on this and have decreased it across the board, but these racial disparities remain. New PM standards are definitely going to save a large number of lives, have a large economic benefit, and generally lead to better health outcomes for communities of color. But frankly, it's not good enough. Like we have to propose bold standards, and we have to do the best that we absolutely can in order to ensure that these disparities are eliminated and that we are giving everyone the same opportunity as a healthy life. Once again, equality versus equity. There are other upcoming rulemakings that WEACT is engaged with that can also help the problem of PM pollution. The light duty vehicle rules are hopefully will be finalized soon. We hope to see the EPA include a requirement of gas particulate filters within that. That would have a substantial effect on particulate matter pollution. We're also waiting on the mercury and air toxics rules to be finalized. That will have an impact on particulate matter pollution. And we're also equally awaiting the Clean Air Act power plant rules to be finalized. And those are all rules that in addition to having impacts in those sectors on other pollutants, have impacts with particulate matter as well. And so with that, David, I'll throw it back to you. Thank you.
Thanks, Manny. And that data reflects the experience we have here in the San Francisco Bay Area with regard to communities near port and freight operations. So that was really excellent presentation. Turn it over to Peter now.
Thanks.
Peter from the Environmental Defense Fund.
Thanks so much, David and Mandy and Amanda. Really appreciate the opportunity to be here today and to talk with you all about EPA's revised and strengthened particulate matter standards. I'm Peter Zalzal, Associate Vice President for Clean Air Strategies at Environmental Defense Fund, and I'm an attorney on our Clean Air team, and EDF has worked on the particulate matter standards that EPA recently strengthened, both through the last review cycle and then historically over the cycles that David and Amanda referenced. And so I wanted to just, briefly add a few points to the ones that Amanda and Manny raised, and, also maybe kind of very briefly focus on some of the health impacts and benefits of the standards. Those are things that I think have been well covered, and then talk a little bit about some of the issues around implementation and opportunities we're seeing. So, I think we've heard this from everyone thus far, but want to underscore from our perspective as well the vital importance of strong particulate pollution standards and EPA's action here in strengthening those standards. Amanda and Manny both showed data that EPA has produced on the benefits and importance of these actions. As part of EDF's comments on the record here, we worked with Industrial Economics, an independent outside firm, to submit analysis during the comment period that is very consistent with the findings that you all have already heard. But in particular, that analysis found that particulate pollution causes about 100,000 premature deaths each year. And as Manny very well laid out, the burden of that pollution is especially harmful in communities that have long borne the heaviest burden from air pollution. So a few statistics from our own analysis there. The industrial economics work found that Black Americans 65 and older are 3 times more likely to die from exposure to soot than white Americans over 65, and people experiencing poverty are 49% more likely to live in an area that exceeded the 12 microgram per cubic meter standard. So one thing I just wanted to make clear around the legal framework that EPA is operating under here is that the Clean Air Act requires EPA to establish national health-based standards that are requisite to protect public health with an adequate margin of safety. And that evaluation does not allow for the consideration of costs in setting the standards. And so that's something that the Supreme Court, in a decision by Justice Scalia in the Whitman versus American Trucking case, makes very clear. And, again, just building from the comments of both Amanda and Manny, there is really an overwhelming body of scientific evidence that supports EPA's decision to strengthen the national health-based standards. The Clean Air Scientific Advisory Committee unanimously recommended strengthening, with a majority of that committee recommending stronger standards in the range of 8 to 10 micrograms per cubic meter. And the benefits of strengthening these standards are significant. And again, I think I will just highlight some findings here. Manny went into this in a lot more detail, but the work we did with industrial economics found that a standard of 9 micrograms per cubic meter would avoid thousands of childhood asthma attacks, trips to the emergency room, and hospitalizations, as well as save thousands of lives. That analysis also indicated that when the rule is implemented, there would be the greatest per capita benefits from meeting a standard of 9 for Black Americans. There would be a reduction in 61 air pollution deaths per 100,000 people per year. And as Manny said, I think it's very important for us to acknowledge that many groups, including EDF, advocated for even more, protective standards based on our assessment of the record evidence, including stronger 24-hour standards, and that there is more to do even with the strongest standards possible. There is more to do to protect public health and reduce disparities that communities are experiencing right now. So I did want to spend a little bit of time, in addition to the level of the standard, which is quite important. It is also important in our view to sort of talk about how the standard is implemented and ensure that that implementation is really rigorous. And so Amanda touched on this, and I think one of the really important features of the final rule, in our view, is the way in which it starts to strengthen the existing monitoring network by ensuring that there's a consideration of citing additional monitors in at-risk communities. And so, everything we just, I think, discussed underscores that communities experience air pollution burdens differently and inequitably. And, EDF did an analysis in West Oakland in partnership with Google Street View cars that showed really substantial air pollution variability, even across a couple streets in neighborhoods. And so, beginning to reflect that those sorts of differences and disparities in where monitors are cited, in our view, is really an important step forward in what EPA has done here. We included this in our comments on the rulemaking, but think there are opportunities to kind of continue to build from and strengthen those approaches. So in particular, we've seen really, an explosion of data from news sources, advanced technologies like satellites, sensor networks that are providing, really substantial information on air pollution levels outside of those that are delivered by the existing monitoring network. So in addition to informing decisions about where monitors are cited, I think there's an opportunity for EPA to start using that data more directly. There are a couple ways to do that potentially, to think about using that information to supply missing data from the existing monitoring network. So there's 1 in 3, 1 in 6 day requirements for particulate matter monitoring, and also to factor into and consider as part of how the agency makes designations, particularly in areas that would be designated as attainment or unclassifiable because there's not an existing monitor or information there. So see that as a really important opportunity, going forward to strengthen the health protections that everyone experiences. Also wanted to just say a word about the really common sense solutions that are available already and that EPA is advancing that will cut particulate pollution. So Manny referenced these rules as well. We are, looking forward to EPA taking final action on both light and medium duty standards for vehicles as well as heavy duty standards. So EDF did an analysis, a health impacts analysis of those standards just based on the proposals that EPA put out, and found cumulatively they would reduce 261,000 tons of fine particulate matter and avoid over 40,000 premature deaths. And really there are aspects of those standards like the gas particulate filter requirements that were mentioned that are critical and vital to secure those reductions. All of these, that's just one set of standards that EPA is advancing now that will help to restore healthy air quality in communities across the country. Based on the suite of measures that are under consideration and in process, EPA found that 99% of existing counties would be in attainment by 2032. And so I think that just sort of underscores that there are solutions that are available and that are being advanced that will help to restore healthy air quality. And then, the final thing I'd like to highlight is just to say a word about the success of the program. Amanda included the graphic about how clean air quality has improved while we have experienced economic growth across the country over time. And so would like to just build on that, because we are seeing now, as we have seen, naysayers about the likely success and impacts of the program. In 1997, then U.S. Senator Spencer Abraham claimed that hair salons and other businesses would be shut down on a basis of then adopted standards for particulate matter. And so these, skies falling claims have been refuted over the long history of the Clean Air Act. And there is a time-tested and well-documented history of innovation and collaboration. We have experienced economic growth while improving air quality over time. And the final thing I'd say about this is, I think we are even more optimistic about this going forward. I think the history has shown a consistency. Economic growth is consistent with air quality improvements. Now with laws like the Inflation Reduction Act, I think we're seeing an opportunity going forward where air quality improvements can help to catalyze economic growth. So, we'll give you one example. EDF put out a report yesterday looking at investments in the IRA and in clean vehicle manufacturing here in the U.S. and the jobs associated with those manufacturing investments. Found $188 billion of investment, 200,000 jobs to make clean vehicles and batteries here. And those are the very vehicles that are going to help to cut 260,000 tons of particulates and avoid 40,000 premature deaths. And so there's a real opportunity going forward in this moment of inflection to accelerate clean air progress while we see, increasing job growth and economic prosperity. So with that, we'll turn it back to David.
Thanks, Peter. That was great. I think I'm going to lead off. I'll lead off the questioning with one for Amanda that reflects some of the questions we got in the Q&A. So Amanda, maybe you can sketch a little bit for us, sort of what comes next. How does EPA, the states, and source operators react to the new standard? And maybe you can sketch some of the schedule there. And then one of the questions out there was how many areas of the country would be affected? And Peter touched on that, but maybe you can tell us a little bit more about how many go from attainment to non-attainment in the short term. How many need to file SIP, new state implementation plans, for example? Oh, there's a lot of questions in there. Sorry, I can repeat if you need me to. But what comes next is the first one.
No problem. So I anticipated this question, thank you, and have some slides to run through the schedule from here. But I think I want to start by saying I came, as you heard, from an academic background, and with that hat on, I think of the NAAQS as a real blunt instrument. It's a national standard that is a goal. And the devil is in the details of the implementation and how different areas of the country work to come into attainment with that goal. And there are many areas of the country, as we're going to see, not very many, only about 1%, but it's still a significant, you'll see it on a map in a minute, areas where it's an out of reach goal. It's a goal that they're still striving toward and they're not reaching. And as you heard from Manny, those areas of the country are what I was terming at-risk communities. They tend to be lower socioeconomic status, communities of color, et cetera. So what happens once the standard is reset? That's step one. We've completed that step. We did our extensive scientific review. We're barred, as you heard, from considering cost or attainability and setting the NAAQS. It's supposed to be, and was, from my experience, based entirely on the health science. What do we know and what can we say about what levels are important to achieve better public health results? The next step is the difficult step. It's the implementation step. States and tribes, where appropriate, have to actually bring pollution in those areas down to meet the standards. And that's the point at which cost, technical feasibility, the time required to meet the standards, et cetera, can all be taken into account. So as you see on the slide, the final rule does not take it does not make the actual designation determinations for different areas of the country. That happens next. And if I can have the next slide. So this is a map of the areas of the country that already meet the strengthened PM 2.5 standard. And I want to emphasize here that this is based on data from 2020 to 2022. It is absolutely not intended to be predictive of the outcome of our designation exercise, which will come next and will be based on newer data. But most counties around the country do already meet this standard. Excuse me one second, my notes have disappeared behind a different screen over here. So of the 119 counties with 2020 to 2022 design values that are above 9 micrograms per meter cubed, 59 of them are already totally or partially contained in non-attainment areas for the current PM 2.5 standard of 12. So as I was saying earlier, the devil is in the details. There are still areas of the country that are not yet in attainment with the 2012 standards. Shouldn't come as a surprise, first of all, that when we lower the standard, they're going to remain or likely to remain out of attainment. And also shouldn't come as a surprise that they are disproportionately in at-risk areas. So the next map shows, if I can have the next slide, the next map is also based on 2020 to 2022 air monitoring data. Again, I want to emphasize that it is not intended to be predictive of what's going to happen in our designation process. But this shows projected emissions for 2032 based on emissions from 2016 to 2020 monitoring data. And it reflects the emissions control rules that were finalized as of March 2023. It does not reflect some of the rules you just heard about from Peter that are still forthcoming. And as this map shows, more than 99% of counties are expected to meet the revised standard as of 2032. But we still have these blue hotspots in areas of the country that are predicted not to be in attainment as of 2032. And again, that reflects in part some of the disparate impacts that Manny was discussing. So if I can have the next slide. The steps from here, this slide is a little upside down, so I'm gonna read from the bottom up. So within 2 years of having finalized the new standard, we have an obligation to designate areas as meeting or not meeting that standard, so attainment or non-attainment, considering the most recent air quality monitoring data. So over the next 2 years, we'll be evaluating and designating areas as, around the country as in or out of attainment. The process then shifts for most areas of the country to states, tribes, and localities that have the job of trying to keep the airsheds in attainment, if they're in attainment, or bring non-attainment airsheds into attainment. And they do that in part through permitting of large sources, and my last slide, I'll run through how that works. In part through other kinds of air pollution approaches that they adopt through their state implementation plans. In areas that are not in attainment, non-attainment areas, though, some very strict non-attainment new source review permitting standards come into effect. So in those areas, large new sources or facilities that are going to modify in ways that are going to increase their emissions are subject to very strict standards in terms of the pollution controls that they need to adopt in order to come online. And if there's interest, I can walk through in response to a later question exactly how that permitting process works, depending where you are in the process. Can I have the last slide? So from that, so at 2 years, we have to redesignate whether areas are in attainment or non-attainment. Within 3 years of the finalization of the rule, the Clean Air Act Section 110 requires all states to submit state implementation plan revisions that show they have the basic air quality management program in place to implement the final NAAQS. Within 18 months after the effective date of designation, non-attainment area PM 2.5 state implementation plans are due. And then finally, at the end of the 6th calendar year after the effective date of designations, moderate non-attainment areas are expected to come into attainment. But as you saw from the maps, that may be optimistic in some areas of the country.
So, Amanda, can I go on to the questions? Are you there? Are you finished there? Okay, that was great. That's exactly what we needed to respond to some of the questions. Manny, let me turn to you for a second. One of the questions we got was from someone saying, how can we get some more monitors as a result of this rule? And you know, kind of is there other things that local groups need to be paying attention to relative to this question about monitors?
Yeah, so I honestly am not familiar with the exact protocol to get EPA to add a new monitor in your region. That might be something Amanda might have more info. But what I can say is that there are a lot of grants out there right now that are part of the Bipartisan Infrastructure Law and the IRA, as well as, you know, just various other sources of money that are available for groups that want to put up air quality monitoring. Especially for PM, there are a lot of excellent low-cost sensors available, like purple air sensors that you can put up to get an idea. These are not monitors that the EPA will use for their regulations, but they are useful in making the case that your region is experiencing, you know, air pollution that needs to be addressed. I know WEACT has recently gotten various grants to put up a large number of monitors in northern Manhattan, and along with groups that we work with in the Bronx. And so we're putting up upwards of 55 monitors in those two places that will give us some great real-time data. So there are, you know, avenues for that kind of data to be acquired, and there's a lot of money out there right now to do that. But I think on the EPA monitor specifically, maybe Amanda has more information on that, or at least direct us to somebody who can answer that. I do not have that information, unfortunately.
So I don't have exactly that answer at my fingertips, but I put in the chat the terrific EPA site that I was exploring as I put the slides together, that gives access to all of the data that we collect from the monitors nationwide. You can focus in on your area. You can look at the data from the monitors that are closest to where you are. It also includes information about handheld monitors that you can actually purchase. They're not that expensive, and you can do your own monitoring. And there is an FAQ on the site. I just couldn't find it just now, but I saw it last night, about how to request that EPA use your data. I think that the answer is often we don't, because it needs to meet a certain level of quality assurance, but it's a question we anticipated.
Yeah, and I don't, maybe if I could just add a little bit there. We do have and can share more examples in this example with folks, but there's a good example of a community outside of Houston in Pleasantville, identifying information through some of the techniques that Manny, you and Amanda just mentioned, to get a new monitor cited, a new PM monitor cited there, given kind of elevated pollution levels. And then wanted to just return to kind of some of the points I was making during the earlier part of the discussion. It's where we see and recognize, there are some questions that have to be answered and some challenges associated with it, but we have this just enormous universe of information through sensor network satellites, and it's not information that's produced in the same way as EPA's existing monitoring network, but it is really valuable information. And so see opportunities, so we don't have to wait, potential years for siting of a new monitor. How do we use that information right now to help strengthen, the decisions we're making around air quality management and planning? And so that's I think just an important opportunity for us to consider going forward more directly using that data.
Yeah, and from my experience in the San Francisco Bay Area, there's been decades of really good citizen science, and EDF contributed heavily to that with the new mobile monitoring. But it strikes me that that just having people go to the regional EPA offices and ask, so what are you doing with regard to the siting, and get a briefing from them, and just raising the question, it seems to me, might be a useful thing to do at this point. Let me turn to some other questions here. One that is pertinent to particularly the Western states, about does the rule affect the ability to do prescribed fire prevention efforts? And also, how do particulate matter from fires affect non-attainment and state planning? I don't have a single idea about the answer to that question. Do any of you thought about that?
I can jump in unless either of you has thought about that. I can jump in to say that this is something we heard a lot about in the rule preparation. In November of 2023, we and the Department of Interior, USDA, and the Center for Disease Control signed an updated memorandum of understanding on wildland fire and air quality. And we have a work plan to address some of the concerns that you heard in the question. First of all, obviously, most important, to protect communities from the impacts of wildfire smoke, while scaling up prescribed fire to reduce the risk of larger and more severe fires, to ensure that we have pathways under the Clean Air Act to permit and allow for increased prescribed fire, and to resolve some of the challenges through on-the-ground tabletop exercises, which will support prescribed fire and public health protections. So to sort of understand how best to do a prescribed fire in a way that minimizes the health impacts. We are working on putting together, if it's completed, I don't know about it. We are working on putting together an efficient, user-friendly pathway for excluding data that are impacted by prescribed fire and wildfire smoke from the NAAQS evaluation to help states address the exceptional events process. And this, of course, as climate concerns increase, this, of course, is going to be very important to both minimize those impacts, but also assist states with coming into compliance in spite of the need to do these prescribed fires.
Peter or Manny, do you have anything to add on that?
No, I think Amanda covered it.
Yeah.
Yes. So Peter, has the litigation begun? One question we got was, is it possible that the litigation will affect the attainment designation, or will that go forward regardless of the petitions for review filed in the U.S. Court of Appeals?
Yeah, I mean, I guess the last question first, I think and Amanda could say something if I'm getting this wrong, but our expectation is that the designation process would move forward as she described, and as it always has under the provisions of the Clean Air Act. There has been litigation filed. A number of states, I think led by Kentucky, filed a legal challenge. Texas has filed a separate legal challenge, and I believe there's a challenge that's been filed by a number of industry trade organizations as well.
So the industry one I've seen is the National Association of Manufacturers, American Chemistry Council, American Forest and Paper Association, API, American Petroleum Institute, American Wood Council, U.S. Chamber of Commerce, National Mining Association, and the Portland Cement Association. And I agree with Peter that we would go forward with designation unless, of course, the rule is stayed. And I add that only because that's been a remedy that some courts have applied with increasing frequency recently.
There's a interesting question about how should states implement the new standard with regard to minor source permits in this process. I'm not sure I posed that properly, but I guess the broader question is, what impact does the rule have on relatively small sources of particulate matter?
There, if you want to take that.
Well, I can take a stab at it. And so I think that, you know, in the end, it really depends on what the non-attainment areas are that the EPA designates. And it's important to note that these are not going to be aimed at any one facility or, you know, any one industry. These are areas where the air quality has been deemed to not meet these standards. And so, you know, it's a holistic approach in that everything that emits particulate matter from that area is subject to you know, being part of that designation. And so I think that largely it's not going to be something where the needle or the straw is going to break a camel's back, right? It's going to be these bigger influences that are overarching throughout the region that have the biggest impact and are going to be most at danger of being regulated. So we haven't really, you know, been too worried about that from WEAC's perspective, but I don't know, maybe Peter might have a different point of view on that.
No, I mean, I think most of what we've heard are questions that have been raised around the major source permitting issues that Amanda identified. So in areas that are attainment or unclassifiable, the PSD permits that big facilities are required to get when they construct or make, you know, a major modification, or in non-attainment areas, the non-attainment new source review. And so, you know, and to be clear, I think we think that there are a lot of approaches that those facilities can take to reduce their pollution, and, you know, construct and be in compliance with the law and also clean up the air. We have not heard the same, you know, questions around the impacts on kind of minor sources from a permitting standpoint.
Yeah, and
I'll just
experience is that states and local air quality authorities have been moving forward on this on these a wide variety of sources. The Bay Area Air Quality Management District, for example, has adopted rules affecting gas systems in buildings, for example, HVAC systems in buildings, but at the same time moved to impose tighter particulate matter limits on refineries in the region. And in Southern California, you see that the South Coast Air Quality Management District kind of looking for new sources to go after because it's hard to reach that standard. So you're seeing things like consideration of indirect source kinds of rules affecting warehousing and transportation centers. Ocean-going vessels is another potential area. So I think my sense is it stimulates a lot of questions about where do we go next, and the technology is evolving very quickly, and you're going to see a wide range of innovation on different kinds of sources being subject to controls. Peter,
I'm sorry, can I just jump in quickly?
Correct me if I said that wrong.
No. So just going out to a 20,000-foot level for a second, the way the Clean Air Act works, when area is designated as non-attainment, certain kinds of major source permitting requirements kick in automatically under the Act. But for minor sources, it's left very deliberately up to states, tribes, and localities to assess the best approach for their region. So for example, I'm in Washington, in DC, we have some anti-idling rules. Those are DC based, those address particulate matter and smog and various other forms of pollution from idling engines. That's a DC based decision that one of the ways they want to address the NAAQS for those pollutants is to reduce idling on public streets. Intercept parking, changes to ports, moving the location of different kinds of development, et cetera. Zoning laws are all ways that states and localities can choose to address pollution. The zoning laws, of course, are one of the sources of the redlining problems that Manning highlighted earlier. But those decisions tend to be made at the local level.
Peter, I can't resist asking, how hard would it be for a Republican president to repeal this rule or undermine its implementation? My sense is that it's not automatic that would happen, but do you see a risk there?
So I think if a future administration wanted to revisit the rule, there would have to be a process of administrative reconsideration, a proposal, go through, a public comment process, consider those comments and take final action. And so that's, a long process, I guess is the first thing to say about it. And then, I think the other thing is, as I know, we're all talking about shifts in different administrations over time. It's important to just, I think, ground ourselves in the law and the substance here. And I think the law is very clear in terms of like what EPA needs to consider when it sets these standards. And that's, the public health considerations alone. And of course, in the implementation process, as we were all just talking about, there's provision for considering costs and making sure approaches work to restore healthy air quality. But that's clear in terms of the legal framework. And then, the scientific evidence here is overwhelming. I mean, it is overwhelming on the need for stronger standards. And so I think both of those factors, that we're operating under a settled legal framework, opinion by Justice Scalia, unanimously for the Supreme Court, and an enormously strong factual record suggests that, it would be quite difficult if that's what a future administration wanted to do. And would certainly hope that that's not the case.
Amanda, Peter, Manuel, how do these standards compare with what other countries have done? thinking particularly about the European Union. Any sense about how it compares?
Yeah, I'll jump in here. I think that, the EU just recently updated, and we spent most of this time talking about at least I did, talking about the annual average and didn't talk about the daily average. The EU currently, I believe, had a standard of 25 micrograms, which was what was briefly considered to be updated here. They're updating that to 10. And so that's a much stronger threshold than we currently have here. You know, we believe that there is scientific consensus for updating that standard. I know that the EPA mentioned that the Clean Air Scientific Advisory Council didn't unanimously recommend that, but it's my understanding that it was a pretty large majority and maybe only one vote against it. So I'd say that generally Europe has stronger rules regarding PM pollution than we do, and I do think that that's the direction that WEAC would like us to move it towards.
The fire trucks were going by. That's why I was on mute, but they're gone now. So, Manny, could you expand a little bit more on sort of what are things that states and local governments can do specifically to reduce exposure in minority and low income areas? It seems to me that there's a wide range of options there, kind of in addition to implementing this the new standard.
Yeah, so Amanda just touched on this briefly a second ago, and we both live in DC, and DC has specific ordinances here that are aimed at curbing air pollution that other places can implement as well. And states are not limited to just following the PMX. They're able to enforce state laws that are apply regulations in addition to what the EPA guidance is. The EPA sets a national level, but states are free to come in and set higher levels, or add additional reviews on top of what's required by the Clean Air Act. And so there's a lot of freedom. I think that that is something that is hardening, right? In places like California and New Jersey, we see states taking steps to alleviate some of these burdens that are disproportionate to communities of color, and those are really welcome steps. I think what's unfortunate is that other states don't have to do that, and the way that other states implement the Clean Air Act can be detrimental to communities of color in those states. And I'm thinking specifically of places like Texas and Louisiana, where the enforcement at the state level is nothing like it is in a California or New Jersey. So it's kind of a double-edged sword in that states can, by choosing different enforcement regimes or making additional hurdles for industry to pass, safeguard some of these communities. But that also means that in places where the state governments aren't thinking about prioritizing the health of communities of color, that they can do the opposite there, and they can prioritize industry. So it's just what the nature of having a federal regulation that relies on state implementation. But it's something to keep in mind.
Here's what I think for Peter, but Manuel and Amanda might want to add. So the Supreme Court's decision to revisit Chevron, is this something that could affect the litigation over the standard or implementation of the new standard?
Yeah, I'd welcome others' thoughts. I mean, we're obviously deeply concerned by about arguments that are seeking to overturn the Chevron doctrine. You might go back to kind of the earlier question and my response to that. This is an area where like I don't have the language in front of me from the American trucking case, but I believe It was something like, yeah, paraphrasing, but for the thousands of pages of briefing on this, it would seem clear that EPA cannot consider costs in setting these standards. And so, that didn't rely on Chevron, I guess is my point. That decision did not rely on Chevron and sort of I think made its conclusions based on, the best reading and the clear reading of the statute. So I guess that's one thing I'd say. And then the other is like, this is an area where, EPA, as it's evidenced by the final rule, is acting, really kind of in the heartland of its expertise and evaluating, technical considerations and just an enormous amount of data. And those are, I think, the sorts of things, at least, that came up in the argument around this, where, it seems like, however the court resolves the broader questions around Chevron, these are areas that respect should be accorded to the agency's determinations.
Well, we've got about 10 minutes more. I thought maybe several other questions posed by the audience talk about how will this affect power plants, and I think probably some people are thinking refineries. Kind of like, why don't we just think a little bit in terms of, if you're an operator of a power plant, trying to keep the lights on, how do you respond to, how do you and the state air quality agencies implement this in a way that gets reduced emissions but doesn't create other hazards? And then refineries, I think, is a similar question in terms of fuel supply. So that's a really broad, poorly worded question on my part, but any thoughts? Maybe we take power plants first.
So I'll jump in on this one to note that if you're humming along with your permit in place, this doesn't affect you. This affects large facilities that are moving into an area, building new facilities in an area, or modifying in a way that will significantly increase their emissions. That's the point at which the permitting obligation is triggered. And then that's the point at which, depending on whether you're in an attainment area or a non-attainment area, you would have to work with your permitting authority to assure that you are both meeting the statutory standards, and those statutory standards in terms of what kind of pollution control you need to install vary from a non-attainment area to an attainment area, but also that you're working with whatever other obligations the permitting authority is imposing. So the timeline by which you have to install those controls, that's the sort of interaction point at which the state can increase the requirements if it wants to come up above the next floor, et cetera. So if you're humming along, no implications for you. But if you do need to get a new permit, that's where this rule would have an effect.
Yeah, but local governments might decide that in order to meet the standard, reduced emissions from power plants are one option to look at. Am I right about that? Although, I hasten to add, there's lots of other things affecting that, renewable portfolio standards and a whole series of regulation, electric utility regulation affecting that, the power plant rule. So,
yeah.
Not sure, maybe we've plumbed the depths of that one, but those things will be over, along with the PM 2.5 will be emerging over a fairly long period of time, so that it's not like anything happens tomorrow with either a power plant or a refinery, for example.
Yeah, that was sort of the only addition I was going to make, David, that it really is operating on two different time scales. There's the permitting requirements that Amanda discussed, which are really particular, to certain facilities, and for which there are a number of flexibilities and solutions available. And then the kind of broader implementation of the program, which, as you noted, will occur over many years and as part of, a process led by state and local air quality regulators.
Yeah, and kind of in the context of a rapid evolution in the technology for meeting electric power demand, for example, and dramatic changes in the costs of the alternatives. So there's lots of cross currents occurring at the same time. How about refineries? We have several here in the Bay Area. It's a subject of a lot of controversy, particularly for minority communities living near those facilities. Similarly in Southern California. What effect do you think that might have on refinery emissions?
I mean, I could just speak generally, or Amanda, please weigh in. I think it's similar to what we just talked about for power plants. And what I'd say is, like, there are real opportunities to reduce particulate pollution from refineries, and it's important to do that. And so to the extent that, like, this is, as we discussed, providing a framework to support and allow those reductions to occur, it's really important. And there are opportunities there.
Yeah, I think all I would say is, again, sort of refinery by refinery, the implications are, as I said before, if you permitted, you're permitted. That said, the regulatory landscape is changing. There are, a variety of rules that we've issued recently. There are some others that people are eagerly awaiting, all of which are more likely to have, including the ethylene oxide rule that was mentioned that came out yesterday. Those are sort of more directly aimed at some of the high polluting facilities that we're mentioning. And those have more could have more direct impacts on refineries. I obviously can't speak to any of the rules that haven't yet been promulgated, but
there was one question here about how does this is probably for Amanda, but how does population density play into the revision of the rule, the implementation of the rule?
Question, in terms of the science, I don't actually know whether we take population density into account as we, is that something that you know more about, Peter, as we evaluate the data for health impacts? I mean, we're obviously looking per certain population size in terms of asthma rates, death rates, et cetera, per standardized population size. And I know that we take population density into account in locating the monitors, but beyond that, I'm not sure how else population density is factored in.
I can jump in here. Peter, sorry, I didn't see you come off mute, but you have something.
No, you go.
Okay, so I'll say that if you look at the map of the areas that Amanda put up, we definitely see cities included in there, the counties that are projected to be in non-attainment possibly do contain cities, but we also see a large swath of rural counties, especially out west. And so the problem of particulate matter is definitely one that's associated with your location, but it's and there are situations that being in an urban environment make you predisposed to be at higher exposure. You're closer to areas of high traffic. A lot of times you're sited closer to areas of dense industrial activity. But out west, you're also in rural areas, you're sited in areas of large agricultural activity, which can be a large contributor as well. So I think that while being in the city can make you predisposed to certain forms of PM that come from sources that are typically located in a city, you also face that in rural environments, it's just different sources. So I wouldn't say that being in a city makes you be in a high PM environment. There are plenty of cities out there, very dense areas, that do not have PM levels that exceed the NAAQS. And and there are rural areas that do have these levels. So I think that there is a relationship depending on the industry, but it's not a predetermined thing where rural or urban makes you assured to be in attainment or non-attainment.
Maybe the only just final brief thing I'd add to what Amanda said were, the other way in which at least I'm aware of it coming into play is in the designation process. Sometimes when EPA is considering, whether an area contributes to non-attainment in another area, there's an evaluation of population and how those populations kind of relate to the area with unhealthy air quality, but not in the setting of the standards.
Well, I think we're at time here. I think I've covered all the questions. If I didn't, apologies to the people who posed them, but I want to thank our panelists for their presentations. Very thoughtful conversation here. And so I think to wrap up, I'll turn it over to Madison.
Thank you so much to all of our fantastic speakers for joining us today. Thank you to David for moderating, as well as to Amanda, Manny, and Peter for speaking. We so appreciate all of you taking the time and energy to make this program happen, and appreciate you answering so many audience questions as well. And speaking of our audience, thank you as well to our audience for your time and engagement today. We appreciate all of your many questions, and we apologize if we couldn't get to all of them. There were quite a few today. If you missed any part of today's webinar, the recording will be available to ELI members on the event webpage within a few business days, so be sure to check back there. To find out more about ELI membership and all other ELI programming, we encourage you to check out eli.org. And with that, I'll bring today's webinar to a close. Thank you so much again, everyone, and I hope you have a wonderful day.
Thank you.
Thank you all.